There are really four components, I think, to the ethics laws. The main one that you want to hear about today are the prohibitions. I spend a lot of my day telling people no. No, you can't do that. No, you shouldn't do that. And then I go home and tell my kids the same thing. So rarely do I get to say yes. It's a very exciting thing for me when I work through an issue with an official and they can actually do the thing that they want to do. The main thing that I want to do is keep you from getting in trouble. And I'll start by saying that these prohibitions that we're talking about, the ethics laws at the state level, that is the ground level floor of ethics for you to abide by. There is nothing wrong with holding yourself to a higher standard than what I'm going to talk about today, and I encourage you to hold yourself to a higher standard. But these are the minimum standards, and I'll tell you what, if we could get public officers and employees in Florida to simply abide by the state law, we'd be in a really, really good place. I know there's a push on a lot of local level to have more stringent standards, but we still got people violating state law. So don't forget, even if you have local standards, the state law still holds, and we still hold you accountable for that. So the very first of the prohibitions are the ones that seem to aggravate your constituents the most. And that's the thing of, throwing your weight around, misusing your position, or having access to inside information that you use for your personal benefit. In order to have a misuse under the ethics laws, there has to be a corrupt use of your position or resources and a benefit that you're seeking to get for yourself or for someone else. You have to have both of those components in order to have a misuse violation. So the corrupt element means that you have to have done it with a wrongful intent. You have to have done it on purpose, knowing that it was wrong, but you did it anyway because you wanted to receive some sort of compensation or benefit from that act or omission. And that act or omission has to be inconsistent with a proper performance of your public duties. So in other words, if you have the authority to make certain decisions, it's a discretionary call on your part, and that's a part of your public duty, that decision, even though somebody doesn't like it, can't be said to be inconsistent with your proper performance of public duties and corrupt, okay? So the good news here is mismanagement, waste, negligent acts, not enough for a misuse. Bad in and of themselves will not look good for you. Rude, unprofessional behavior, incompetence, also not a misuse of office, okay? Those things are personnel type related issues for your employees. Those have to be dealt with by supervisors. For you, the people deal with that at the voting booth in terms of that type of behavior. But things like sexual harassment, supervisor to subordinate type sexual harassment situations, we have seen misuse. Any identification of your position in a situation that really has nothing to do with your public capacity could trigger a problem. The do you know who I am scenarios. Those are the things that people get aggravated with. Chairing meetings with a forceful manner, not a misuse of position. City or county charter violations, not a misuse of position. However, we have seen interference with traffic stops. Those have been found to have been misuse. Engaging in campaign activities while on government property, or on duty for employees, that can be a misuse. We've seen in an office where somebody was, making calls to raise campaign donations, to their party or to their particular race. That has been a misuse. Personal purchases with credit cards that belong to the county, that is a misuse. Going and threatening the sheriff, the police chief with your position over a parking ticket, probably not a good idea for you. we saw a number of years ago with us, I think it was a city official. It was kind of a road rage case where somebody was moving too slowly. The official was behind them, got kind of aggravated. Apparently there was a heated exchange between the two. The universal symbol for "you're number one" was raised. The citizen said, I'm going to call the police, and the official said, well, that's fine, because they work for me. Follow me. I'll take you there so you can make that complaint. That was a misuse. Recently, we've seen a city official who was retaliating and threatening to retaliate against city employees because the city manager wouldn't fire an employee that this council person was angry with because of a previous situation. And they'd said that after the next election that manager was going to be out of a job. That issue had a complaint filed against it. I'm not sure if we've moved through to the violation phase yet, but I can tell you with certainty that was a probable cause issue. We've seen the thing, making improvements on private property of friends, the allegations of misuse for that. Years ago, we had a county commissioner who had county workers harvesting watermelons with county equipment and hauling it to market for them. Dubbed that the watermelon caper. You do see things like that. It's a great idea if you don't already have policies in place related to use of credit cards, use of cell phones, use of county vehicles, those sorts of things. If you have policies in place that people are aware of, that they do training on, so that they know what the rules are, that is helpful in terms of determining whether or not somebody's actions were corrupt. So that they know, here's the bright line, here's what you're allowed to do, here's what you're not allowed to do. Then if somebody alleges that somebody was using their office computer to run their personal business, and the commission says, well, there was a policy prohibiting use of the computer for personal pursuits, then that's an easier way to get to that corrupt element of the statute. Okay. We had, I've seen complaints on travel for city and county commissioners saying that they were traveling certain distances when they weren't. We did have a case like that years ago where the person was found in violation. So always, always, always be very careful. Common calls that I get relate to people get mad about code enforcement, do they not? We recently had a complaint where it was alleged that a county commissioner was asking county employees to look for and selectively enforce code violations for against a former relative. Also requesting that a county employee continue a hearing for the benefit of themselves or another party. So be very judicious in the use of your position. You can't help that people might know you're a county commissioner. That's just a part of it. The fact that you're a county commissioner now becomes somewhat of the part of your persona. But if you wind up in some sort of dispute with a local retailer over something that you purchased with them, and then somehow invoke your position and mention that they're going to have a real problem the next time they come down to the county to do some business, that's where you start leaning into a bad territory. So everybody chuckles about different misuse things and that corrupt element, but unfortunately we get many, many, many complaints on this still. And it is really the only section of the ethics code that requires a corrupt intent, that wrongful intent. Everything else that we're going to talk about today does not have a corrupt element within it. Okay. On the flip side of misuse of position is use of inside information, where if you know information that's maybe confidential or not, or will be public but just maybe isn't yet, you're prohibited from using that information in order to benefit yourself or a business entity. So we've seen violations on both of those types of things. Seen things where people take zoning maps out and make the changes that they want and bring them back. It's a problem. All right. What about our relatives and nepotism law? As you all probably already know, you can't hire your relatives into a position with the county. You can't advance, promote, or advocate for them into a position within the county if you are vested with the control. The most common confusion on this law is that your relative could maybe be appointed to a board if you don't vote. No. Your relatives cannot be appointed to serve on any board, even though it's non-compensated. They cannot be appointed by your county commission, even if you abstain from the vote. The abstention does not cure the appointment by that board. You're a part of that board. If the board appoints them, you got a problem under the nepotism law. If your relative was on the board prior to you being elected, they are grandfathered in and can remain. But next up is, but reappointment, whenever the term is up, before you were on the board.
No.
I didn't hear that.
Tell me, though, I got immediately. She cannot serve.
Well,
Because I abstained from the reappointment.
right. The issue is the appointment. The issue is with the appointment, not necessarily the simultaneous service. Okay. His question is, if you're sitting on the commission, can your relative be hired by the county to work for the county?
Sheriff's Department, Fire Department, something like that, under a constitutional officer agreement.
Right. If your county commission is not the one vested with the authority for the appointment or for the hiring, and you don't do any sort of advocating on their behalf, you're completely out of it, then you're going to be okay. So if you have, by charter, a county manager form of hiring, and not just that you've kind of delegated that to the county manager, but a real official, charter or local ordinance law that says county manager does all of it, county commission stays out of it. Then as long as you are completely out of it and you don't go down to somebody and say, hey, you know what? You want to know who's applying for this job? I want to tell you how great they are. Or if you go to them and say, I heard you hired so-and-so for this job, but, my niece applied for that. Then you're all right. But who is your relative? Good thing we have laws to tell us that, right? The ethics statutes actually have 3 different definitions of relatives, just to make things easy on you. This is the second most broad. So this one's the middle child, and it lays out, it goes, if you notice, goes all the way to first cousin. And we have an opinion. I believe what it says, if I can remember, is that your mother's sister's husband is not your uncle. Would seem to be my uncle, but maybe not in terms of the law. So I say that not to completely confuse you, but to tell you that if there is an issue that comes up where you do have a well-qualified relative who wants to serve, and I know sometimes it's hard to get folks to want to serve on these boards, talk to your board attorney, talk to the commission, and let us make sure before you completely dismiss the idea that it's impermissible under the statute. Interestingly, this law does not prohibit relatives from working in the same office or from even supervising one another. Okay? It is for the hiring, advancement, promotion, advocating of your relative.
So you keep that sick, so you can hire your mother as a secretary.
No, but if your mother was already employed as a secretary in that office and you are elected to that office, she does not have to quit. She does not have to quit. She would be grandfathered in, pardon the term, grandfathered in to that position. She could remain in that position, but she'd be effectively frozen. Could not be promoted or advanced.
She's gonna watch you like a hawk.
That's right. Mama is going to look over you every single day.
I wouldn't hire my mom. She would tell me all of
That's right. That's what she was doing. But, they'd be frozen and could not be promoted or advanced, would be able to receive, across-the-board raises or things like that. Okay? All right. I think I got you scared with that one. So any other questions about relatives at the moment? Okay, and now that we know who our relatives are, we had an opinion in 2009, it was 0915, where we talked about a city commission member's relative serving in an uncompensated position on an advisory board. And we said an uncompensated member of an advisory board that's nominated for appointment by a non-related city commission member may continue to serve after their relative is elected to the commission, provided that neither the related commission member nor the commission take any affirmative action to reappoint the advisory board member for their reappointment. The law, the nepotism law in 112-3135 prohibits a collegial body from appointing a relative of one of its members to an advisory board, even if the nomination for appointment was not made by the related commission member. Okay, that's 09-15. Okay, business relationships. You need to try to keep them as separate as possible from your public duties, in a nutshell. There are two different laws that apply to outside employment or business relationship, and there are really four components to them. And of course, there's a section of exemptions that can be applied. The first one we'll talk about is called prohibited business relationships. It's somewhat a little bit of self-dealing. It prohibits you in your official capacity from buying, renting, or leasing goods or services for your agency from your business, including businesses owned by your spouse or your children. Okay? So that's acting in your public capacity to obtain or purchase or lease services. Okay? If you have ownership of a material interest, that's 5% or more ownership, that's considered a material interest under the ethics statute. You want to be sure to remember that this not only includes being an owner or partner or sole proprietor of a business, it includes businesses owned by your spouse or your children. It can also include uncompensated service as a director on a board. Membership in voluntary associations are going to be okay, serving on committees, but if you're an officer or director, you're going to have to be mindful of the prohibited business relationship section of the ethics code. It also moves the other way, where in your private capacity, you can't sell or rent goods or services to the county or any other agency of your political subdivision, so other county offices, according to this law. In 2012, we had an opinion that dealt with this. It was CEO 12-13, and we said that it would be a prohibited conflict were a county commissioner to be employed by a company providing services to the county or to constitutional offices of the county. However, It would not be a prohibited conflict were the company to provide services to other counties or to municipalities located within the county and outside the county.
Who renders those opinions?
The commission itself, the Commission on Ethics, issues those. And they're legally binding on the requester, and they can be appealed to the District Court of Appeal. So it's done during a public session meeting.
School board will be included in there.
Yes. Yes. Okay. All right. One caveat to this opinion was that they could do business with counties outside and municipalities within the county and outside of the county, provided that the company does not pursue providing services in situations where one or more of the other counties or municipalities and their county have combined or contracted or cooperated with one another to get services. So you see, you've got to have that divide, okay? Got to have that divide there for that. There are exemptions. We love exemptions. They're construed narrowly to the prohibited business relationship section. If the business within the county is transacted under a rotation system among all qualified suppliers of the goods or services, we've seen this sometimes with maybe wrecker services where there's an absolute rotation system. If it's awarded through a true sealed competitive bidding process, it can happen. Bear in mind that if you are meeting an exemption, maybe you're a sole source provider of something within your county, that can be an exemption as well. There is a form for that. We have Form 3A, which is a sealed competitive bid form. Form 4A is a sole source exemption form. So if you think that you meet an exemption, let's make sure you talk to your board attorney or talk to the Commission on Ethics and make sure that you dot all the I's and cross all the T's so that the local citizen activist who is interested doesn't ding you on an ethics complaint because you didn't fully comply with the law, okay? And just so you know, you're not being picked on. The prohibited business relationship, these prohibitions that I'm talking about, they apply not only to you, they apply to state level elected officials, they apply to employees of the county, city, and state. We're all subject to all of these provisions of law. It's not just for elected officials. Outside employment issues, in addition to prohibited business relationships, you can't have an employment relationship or a contract with a business entity or agency that's subject to the regulation of the county or that is doing business with the county. So that could potentially affect some of your business dealings within the county, and you'll want to think about it. We've said about regulation that a city planning or building department regulates licensed contractors, but the city commission usually does not. Incidental or passive governmental influence is not regulation. The devil is in the details, as with all of these things. Okay, in addition to the very basic, you can't have a contract or employment with an entity that's regulated by or doing business with your agency. That's pretty straightforward. In addition to that, the fourth component of the law says that you cannot have any contractual relationship that might impede your public duties or pose a continuing or frequently recurring conflict between your private interests or your public duties. This part of the law is really concerned with what might happen. It's very prospective. It's not saying you're a horrible person and you're going to do bad. It's saying the law's not going to allow you to have a position that is going to tempt dishonor. So the more intertwined your outside contractual relationship is with what your public work or public duties are, the more likely you are to have some sort of an impermissible overlap between those two things, a real tug where you might be tempted to favor your private interests and private dealings over the public duties that you have to the county. We had an opinion in 2012 again, 12-9. This dealt with a city official. It was a mayor who was employed by a waste management firm that was under contract with the city to provide commercial solid waste disposal. And the commission said that the mayor was prohibited from working as a consultant for the waste management company that was providing services to the city because they'd have a contractual relationship with a business entity that was subject to the regulation of or doing business with the city, and no exemption would apply to negate that conflict. So he could not have that position. We had another opinion that deals a little bit more with the impermissible overlap, where we said a county commissioner's employment with the sheriff's office in the same county would violate the conflicting contractual relationship section. And that was because it would be an impediment to his public duty to hold both the position of county commissioner and that of an employee of the sheriff's office within the same county, because of the fact that, the county commission's role in approving, amending, or modifying, increasing, reducing, or scrutinizing the budgets or proposed budgets of the sheriff's office. It would be hard to say that the commissioner's objectivity and impartiality as a county commissioner could remain intact through that budgeting process while they were simultaneously employed by the sheriff's office. So the commission said that that would be impermissible under this second part of the statute. Yes, in the back.
And does that apply to a sworn position, non-changed reserve?
I don't know the answer to that, and we may have an opinion on it, but I don't know the answer to that offhand. Other questions on the outside employment? Yes.
A constitutional officer and her husband runs for county commission. Is that a problem?
Not under the ethics laws, no. It would not be a problem for one constitutional officer to have a spouse that runs for another constitutional office.
You mentioned about the sheriff's department. What about the school district?
About working for the school district? I'm not clear, as I stand here right now, on whether or not the county provides any sort of budgetary oversight and things to the school district. So I don't know the answer to that question. It may be different. And that's the thing, these opinions that the commission issues, they apply to that person who seeks them, but they may not be analogous to every situation. So I always encourage folks, if they're looking at employment with another agency, within that political subdivision, that it's worth asking the question before they put into it. You can refuse compensation in writing in advance to avoid a problem under the conflicting and contractual relationship law. It's different than the prohibited business relationships where you could be an uncompensated director of a nonprofit or of some board. But in this, you could refuse to be paid to avoid a problem. But some examples of things that can be a problem, ownership of shares of stock can be considered a contractual relationship, as well as the sales of goods or services. Marriage is not a contract for purposes of this law. Your spouse might disagree. The holding of an office, being a county commissioner, that's not employment or contractual relationship, even though you receive some money for being that elected official. That is not considered employment. And individuals can be business entities, even though they might not be a corporation. This law is written in the present tense. It does not apply to past contractual relationships or potential future contractual relationships that you might have. It's talking about the here and now. Okay? Voting conflicts. My least favorite thing to talk about on the face of the earth would be voting conflicts. It's the subject I dread the most, and probably you do too. I'm sure you're very familiar with the voting conflict law. You cannot vote on a matter if it's going to inure to the special private gain or loss to you, your relative, your business associate, or a principal by whom you're retained, which is, an employer. People often talk about gain. They sometimes forget the loss part of the statute as well. Remember, there is a little voting conflict sheet in the binder for you. Appointed officials have to disclose their interest prior to any participation in the matter, and then they have to abstain. Elected officials, you get to participate in discussion on the matter if you choose under state law, but then you must announce your conflict to the assembly prior to the vote and file that voting conflict form 8B within 15 days with the person who keeps the minutes. There's only going to be a voting conflict if there is special gain or loss to that relative who is with the entity who's coming before the board with something that needs a vote. Okay? So what makes something special? One of my favorite SNL skits, the church lady, but isn't that special? It's not just that there's going to be a gain or loss. It has to be special. A little bit more significant than just a gain or a loss. The commission often looks at things, is the result of the measure, is any gain or loss so remote and speculative that it's hard to really identify? If too many things after the vote have to happen in order for there to be the gain or loss to the relative or to you, the official, then it might be too remote or speculative, and I say might because I'm not going to give you a blanket to go vote, but it might be too remote and speculative for you to actually have a conflict. If the measure coming before you is preliminary or procedural, then you may not have a voting conflict. Now, something's not preliminary and procedural if it is a necessary step in the process for something to happen. You can't say, well, that was just this kind of vote. If voting something down makes it completely an impossibility, then that can't be said to be preliminary or procedural. Oftentimes we'll look at something like the size of the class of the people affected by the measure. So, if you're changing all your zoning maps, in the county, and it's going to affect, thousands and thousands of people, and you're a property owner and you own just your house, your residential property that might be affected by that measure, well, there's going to be too many people affected by that measure for any gain or loss to you to be considered special. Oftentimes, the commission has said something becomes special when you or your interests or the interests of your business associate, relatives, employer constitute around 1% of the class. 1 out of 100 or somewhere close to that. Excuse me. The other thing to consider would be is if you're voting on something that affects maybe a group of landowners, and maybe it's a large group of landowners, but maybe you have a relative whose land ownership in that group is substantial. Maybe they own 40% of the land affected, even though there are 200 landowners within that group. Well, then you can't just say, well, there's enough landowners in there, it doesn't affect them any differently than it would anybody else, because they have significant ownership there. So that could be special. Make sure just my public service announcement on behalf of your board attorneys is to make sure you check your agendas in advance. Look through them really good, especially if you have, outside business activities, and pour through those and look at who has things up for a vote, and give the Ethics Commission or give your county attorney as much advance notice that you are concerned that you might have a voting conflict as possible. Because as you can tell, it can get very complicated, and there are a lot of issues that we have to work through. And we don't want to tell you that you can't vote unless you really, truly can't vote. And sometimes, the last minute things cannot be avoided. We oftentimes will get calls, 4:45 on a day, and they say, well, I got a meeting that's starting in 20 minutes, and I just realized this is on here. Can I vote? We're going to do the best we can for you, but if we can't find something exactly on point, and if we're not completely solid as staff, we're going to tell you not to vote in all likelihood. So look in advance. And recently, we actually had a case where a county official, had voted on some things where the commission found probable cause of a voting conflict. And what the prosecutor in that case, the commission prosecutor is an assistant attorney general. They work out of the office of the attorney general, and they prosecute ethics cases exclusively. And in her recommendation as to whether or not to find probable cause, what she said to the commission was that although the official maintained that they were not aware of this business associate's involvement with the agenda item, they had a fiduciary duty, and that the Ethics Commission should not allow negligent blindness to become a valid defense to a voting conflict violation. The official said, well, I just hadn't really reviewed the agenda material. I didn't realize that person was on there. So you do have, an affirmative duty to look through your materials to see whether or not there's anything on there that you might need to abstain. Yes?
Along the same lines, but maybe a little different. I have a nephew that is the president of the city council in our county, as well as municipalities. If we were doing something with that city, should we both abstain from the vote?
The voting conflict law says that, I believe it says, other than an agency. Right. Give me just a second here. Yes, other than an agency. The law says other than an agency. So, sometimes I get where somebody says, well, that benefited the county, or that benefited the city, that they raised these fees, that benefited the city or the county. That doesn't give you a voting conflict, because it says other than an agency. Okay. We had a recent voting conflict violation back in May, where an official, I think it was a county commissioner, had voted on a measure that affected a business associate. And they voted a couple of times, and they wound up with a $2,000 civil penalty for that particular vote in terms of what the Ethics Commission put on them for that vote. Just because I always take it for granted that people kind of know who the commission is, just briefly, the State Commission on Ethics is a constitutionally independent agency. We have about 22 full-time equivalent employees that work here in Tallahassee. We serve at the pleasure of our executive director. Our executive director is hired by our commission. Our commission is a 9-member, non-compensated body. It is bipartisan. There can never be more than 5 from the same political party serving at any time. 5 are appointed by the governor, with no more than 3 from the same political party. 2 by the Speaker of the House. They have to be from different parties. 2 by the Senate President, from different parties. So if you ever come before the commission for an opinion request, or heaven forbid, a complaint, those are the folks you'll be seeing. They come from all over the state, all walks of life. We have former elected officials. We have, of course, our share of attorneys who serve on the board, but we've had school teachers, college professors, we've had a pastor, a rabbi, real estate executives, insurance executives, all sorts of people from all over the state, and they take their job very seriously. They do a lot of review of the materials, and they know what's at stake when people come before the commission. But all of our meetings are here in Tallahassee. It's the staff that answers the questions, and then the commission that does the heavy lifting, and staff does whatever the commission wants them to. Okay. Gifts, the quid pro quos, we talked about that a little bit this morning. If you are taking bribes, if you're taking bribes or accepting things of value for your official action, you've got bigger problems than the Ethics Commission. But the Ethics Commission can still be a thorn in your side on it, doggone it. And you're not allowed to do that. And I long for the day when I do a training session of elected officials where I don't have to say it. But I have to say it because, like you said, there was a quorum in federal prison from Palm Beach County. People still do it, and I don't claim to understand it, and I'm sorry for all of us that it happens because, a few bad apples can spoil the whole bunch, and that's just unfortunate. But you can't ask for anything or accept anything based on the understanding that it's going to influence you. Next one I call You Should Have Known, because there's an unauthorized compensation section of the law that says that you cannot accept anything of value, a loan, a reward, a promise of future employment, if you knew or should have known that it was being given to influence you. This unauthorized compensation section also applies to your spouse and your minor children. So we're talking about that job, the quid pro quo. Sometimes it's the obvious stuff like jobs or some sort of contribution, but other times it'll be more subtle. We have an opinion that we issued back in the 80s where a university administrator was responsible for evaluating the food service on the university campus, and the company that had the contract at that time wanted to give a meal card to that official so that they could, the stated purpose was to evaluate the food service on campus. However, this was a free, unlimited meal card. And this official sought an opinion from the commission. They asked, can I take this gift from this entity that has a contract with the university? And the commission said that under unauthorized compensation, it could not accept the free, unlimited meal card because the potentially great value of what was being received, free, unlimited meals, even if it was from a university cafeteria, negated the stated purpose of giving the gift. And so they could not take it under this statute. So that's a little bit more subtle of an example where you have to be careful. And those two sections, the quid pro quo, they apply to all public officers and employees, okay, at state and local level. Now, reporting individuals, which you all are, that wonderful Form 6 that you fill out before you qualify to run for office, which you will do every July, or earlier, please, while you serve in office. Being a reporting individual makes you subject to additional standards related to gifts. First thing you need to know is that you can't solicit a gift in any amount from somebody who is a lobbyist of your county or the partner, firm, principal, employer of the lobbyist, or a CCE, PAC, things like that. You cannot solicit a gift for your benefit, for the benefit of your immediate family, or for the benefit of another reporting individual. Can't ask for it in any amount. Yes?
Well, this is a question, what about campaign donations?
Campaign donations are a special class of gifts. They're governed under campaign finance law, so lawfully made and lawfully accepted campaign donations, lawfully reported, are not the gift law. And incidentally, a campaign donation does not give you a voting conflict in and of itself, okay? Just because somebody gave you a campaign donation doesn't mean you have to abstain on a vote when something comes up for that person, okay? Who is a lobbyist? A lobbyist is going to be somebody who's paid, who's seeking to influence the governmental decision-making, or who within the last 12 months has sought to influence the official decision-making of you or of your agency, or has sought to encourage the passage, defeat, or modification of any proposal by you or your agency. So that's a big old umbrella, isn't it? That's not John Q. Citizen who's there to talk to the county commission, about people not having their dogs on a leash. That's going to be the people who are paid. So as a reporting individual, you can't ask a lobbyist for anything, no matter what the value. In addition to the fact that you can't ask them for anything, sometimes they might give you something without you asking. Maybe it's a meal, maybe it's tickets, maybe it's a golf outing. You cannot accept any gift, directly or indirectly, from a lobbyist that's worth more than $100. It's prohibited. If it's $100, the answer is no. Or you can always pay for it. That's allowed. I'm not saying you can't go golfing. I'm not saying you can't go to the symphony. Maybe you just have to buy your tickets, okay? If it's over $100, maybe it's $150, you could always pay $50 to get it down to $100, if you wish. Technically, the lobbyist is supposed to report that they gave you a gift if they give you a gift valued between $25 and $100. That's their responsibility, not yours. That's a donor's Form 30 that they would file with the commission.
I have a question on that. What if somebody is a representative of a company representing only their individual company's interests, but they're really going door-to-door lobbying each commissioner on something that they have coming up, and they send you something? We had it happen at Christmas, and we wanted to give it all back to them. They were closed for Christmas, so we gave all these baskets of things to a local charity.
Right. Well, the definition of gift is something that you receive that you don't give equal or greater consideration of within 90 days. So you have 90 days to sort of figure it out. Give it back, pay it down, whatever the decision may be. We see a lot of it around the holidays. What you have to be careful of, the law doesn't prohibit gifts to the agency. The law prohibits gifts to the individuals. So if somebody comes in and gives you a gift basket, then you've received a gift of a gift basket. If you choose to take that basket home, or maybe you choose to give that basket away, they still intended to give you that gift, and you received that gift. If it's more than $100, it'd be a prohibited gift. Okay? So somebody might give you tickets, and you might say, well, I'm not really a Justin Bieber fan, so I'm going to give these tickets to my neighbors whose daughter is a Justin Bieber nut. You still have to write that you accepted 2 tickets to Justin Bieber. I don't know what people in your area think about that, because it's Justin Bieber. But that's a gift that you accepted. If you don't want the tickets, give them back. Okay? But if you choose to do something else with the tickets, you've accepted the tickets and you can do whatever you wanted with them. You've received the gift. Yes, right?
What if they gave the whole board, if they gave all 5 of us a gift basket? Is that still
Each
the
of
same?
you received a gift.
Individual still, it's
Each-
not as a group? Okay.
Yep. Now, if they walked into the county administrative offices and brought gift baskets in and said, these baskets are for all the county people, then that, you're going to be all right. Okay? That you're going to be all right. But we do see a lot of it around holidays. We see a lot of it in football season. If you receive 2 tickets to a football game, is the value of the ticket the 1 ticket or the 2? Even if you give the other ticket away, it's the value of the 2 tickets, because that's an indirect gift to you. The fact that you got a ticket that you could bring somebody else with you, you still got the gift. So the general rule is cost to the donor. Lodging in a private residence is valued at $44 a night. Transportation, lodging, recreation, entertainment, if you're doing a trip, you value it all together. You can't say, well, we had dinner this one night, and we went went to this club the other night, and then we had a brunch, and we'll value all that separate, all together, okay? What the law says is if the charitable event, if you are given a ticket to an event by the charity, and there's a portion of that ticket that is a charitable contribution, the value of the charitable contribution can be backed out of the value of the gift, but only when it's from the charity. So if it's, the American Heart Association gives you a ticket to something, and maybe it's a $125 ticket, and $105 of it is a charitable donation, then the value of your gift is $20. Or if you get two, it'd be $40. However, if a ticket to a charitable event is given to you by somebody else, then the amount of the gift is going to be the $125 ticket. Or if there are two, it's going to be $250. You can only back out the charitable contribution if it's from the actual charity. The charity's giving it to you. You don't have to accept all the gifts that are offered to you. I'll give you the freedom to say no. But that's right. You can pay it down. You can pay the whole thing, or you can say, I'm sorry. It's easier if I just don't take gifts, because then I don't have to think about whether or not they're reportable. Now, I've already said that gifts from relatives are not reportable and not prohibited. The relative definition for gifts is the largest, most inclusive definition of relatives that we have in the ethics code, because the legislature in their wisdom made it so. And so your relative, for purposes of the gifts law only, not nepotism and not voting, but gifts law is going to be all of the usual suspects, right? The in-laws, the steps, the greats, the grandparents, the halves, and then you're going to talk about, it goes all the way to somebody that you're engaged to be married to, or somebody who holds himself or herself out to be, or is generally known as the person whom you intend to marry. Okay? Or with whom you intend to form a household, or any other person who shares the same legal residence as you do, even if they're not actually related. So somebody, shares your same residence, but you're not related, and you're not fiance, and you're not boyfriend. Those, you can accept gifts from those people without the reporting requirements on them. Now, reporting requirements on you. Quarterly Form 9, only if you receive a reportable gift. A reportable gift for you is going to be any gift that is valued at more than $100 that you accept from somebody who is not a lobbyist, because over $100 from a lobbyist is prohibited, not a lobbyist, and not a relative. Who's left, right? Friends. Maybe you have friends. Maybe you have friends that you had before you were elected to office, right? Longtime friends, people who have nothing to do with your public job, people who just like you for you. They've been giving you birthday gifts since you were 8 years old. Those people. Gifts from them, if they're valued at more than $100, are reportable. So think about that. If you go visit your friend out of state and stay at their house for more than 2 nights, you might have a reportable gift. Lodging at a personal residence is $44 a night. 2 nights is $88. 3 nights is, math majors? Okay, we'll go with that. And I should have paid more attention when they were doing all the word problems, if a train leaves the station in Boston. And that's what I feel like I do all day. But I love gift questions for some sick reason. If you receive, I don't make the laws, I just tell people I'm just the messenger.
Was there a distinction on that cost of the organization gives you the tickets to the event directly as opposed to somebody else? Is there a distinction whether it's a charity or another organization?
The charity is the only thing that we have in the rules where you can back out the amount of the charitable contribution from the value of the gift. But tickets are face value of the ticket.
Well, the ticket to the dinner is $125.
Yep.
What if it is, it's only charities, not a...
Right. Because the law says it's actual cost to the donor unless there's a more specific law that applies, and tickets are going to be face value of the tickets, because we've got that by rule.
We're running a little short on time.
Okay. Yes, quickly, and then we'll,
Quickly, if the lobbyist reports something over $100, is there any obligation to send you a copy of it that you thought it was worth 80 and they thought it was 120 and they reported you didn't?
well, they better not give you anything that was $120 if they're a lobbyist. Lobbyists don't report gifts that are valued at more than $100 because they're prohibited. They're reporting gifts between 25 and 100, and those get reported, I think, to us. They get reported on a Form 30. No obligation for you. Yours is that quarterly Form 9, gifts over $100 that are received from people who are not relatives and not lobbyists. If you don't have any gifts to report, don't file anything. Yes?
All right, did I hear you say that if I go to leave here tonight, Friday night, and I go to Valdosta, Georgia, and stay with my good friend for 3 nights, and then go back down there, that I have a problem?
You don't have a problem, you just have a reportable gift. And if you didn't hear the question in the back, it was, if I leave town and go to my friend's house in Valdosta and stay for 3 nights and then come back, do I have a problem? It's not a problem, it's just a reportable gift. Yes?
Some of us have 2 jobs, and if we're doing things on our other job, let's say my other job may involve traveling somewhere to look at another company on a private jet or whatever, is that?
Things that are related to your private employment under definitions of gifts are going to be exempted from the definition of gifts. Salaries, benefits, services, fees, commission, gifts, or expenses associated primarily with your employment, business, or service as an officer or director of a corporation that's unrelated to your public position, those are not gifts under the law. Okay? Moving quickly, because I know y'all will want to eat. You can't wait for her to ruin your lunch. Honoraria, event-related expenses are things when you go speak somewhere. Maybe they want to cover your transportation, food, beverage, lodging, and registration for you or for you and your spouse. That's permitted under the law. If it is from a lobbyist, you can accept it, but it must be reported on a Form 10. Form 10s are due July 1st. There's no grace period for that. But you cannot accept a payment for speaking, okay, that has to do with your public position. But you can accept actual and reasonable transportation, food, beverage, lodges, and lodging for yourself and your spouse. Okay, quickly, revolving doors. You can't be a public official forever, right? You're gonna want to get out at some point, maybe. You cannot turn around and represent another person or entity before the county commission for 2 years after you leave office. It's a 2-year revolving door prohibition on elected officials. That's the Board of County Commissioners, the Chief Administrative Officer of the county, the immediate support staff, and you need to be very, very careful about that. CEO 06-22 deals with county commissioners directly about attending county staff and board meetings. We have even, representation is very broad. Speaking, telephone, texting, calling, emailing, actual physical attendance at meetings, even if you do not speak.
You can't go to a meeting for 2 years if I can't go to a meeting for 2 years.
If somebody's paying you, if you're representing somebody.
Private school, Mom.
You get to be a citizen. If you still want to go to meetings after you're not in office anymore, you might need to see somebody for that.
So what about advice? Can you give advice? We can't give advice at all.
You can have work and you can give advice, but you can't be the person to represent for 2 years. Okay? So, what about your employees or appointees? Doesn't apply to them. If you want to have revolving door restrictions on your employees or appointees at the county level, you're going to have to enact a standard at the local level. Okay? There's nothing in state law that addresses them. Transparency. Everyone's favorite buzzword, isn't it? These forms, Form 6s, Form 1s for employees, due July 1st. Get them in. Do not be late. Keep a copy. They go out in late May. They'll arrive in the mail. You have to fill it out, and you know what else? you have to read those directions. You just have to, or you're going to wind up in front of the commission with an ethics complaint because somebody else is reading the directions. The press is reading them. Your political opponents are reading them. They're going to find something if you haven't read those directions. Thing to remember, we issued an opinion in 2012 about Form 6. Investment products that you hold in IRAs, 401ks, the Florida Retirement Investment Plan, the Florida Prepaid College Plan, in drop accounts, those things should be reported as assets on the Form 6 if their value exceeds the reporting threshold. If you have funds held in a bank, a credit union, or other institutional account, they should be also identified as an asset. Okay, savings account, however much money is in it. If you stash cash in a safe at home, lucky you, you might have to report that as cash on your form when you file it.
And then you would publish that?
I will say this, the commission did not ask for this language. It is something that I believe is in both bills, that these forms will not just be a public record, but they will be put up on the web. The only things that we're by law allowed to redact are things like social security numbers, former law enforcement. If you have a reason to have your personal information confidential, if you're former law enforcement or you work child support or those kinds of people who are specifically exempted under 119, you need to provide a separate letter so that we can mark you as confidential. But unless that gets stricken from the pending law, the 6s will go up. And there's language to make the filing online in the future where you'd be doing online filing instead of paper filing. There's a bunch of forms, a slew of forms even. Form 2 I did not mention, but just real quickly, a Form 2 is for people you represent, or people your firm represents before other entities at the same level of government. So if you're with a law firm or you have an engineering firm or an architecture firm, and somebody in your firm is representing clients before other entities in county government, a Form 2 might be something you need to look into. Complaints, you don't want one filed against you, but after you've been in office for a certain period of time, it may happen. We won't investigate you without you knowing it. The complaints cannot be filed anonymously, and you will receive a copy of the complaint that's been filed against you. Okay, so you will know, you'll have ample opportunity to speak to our investigators and come before the commission. They're confidential and exempt from public records law. We will not confirm or deny the existence of a complaint until it becomes public record. We can't control what you or the complainant choose to talk about. Freedom of speech, it still exists. So that is up to you. Opinions. And I'm just a little bit long and I apologize. Opinions are something you want to ask for. I got plenty of them, but those aren't the opinions that you want. The ones you want are the ones that our legal staff can give you. You can call our office every day. You'll get a live person. You can speak to me or a member of the legal team. One of our lawyers is always handling calls and who I talk to when I'm dealing with questions, so we make sure that we are getting correct information over the phone. We're glad to talk to you on the phone. Then if you decide you need something in writing, you can get a letter from our staff attorney, but you have to write and put the facts in writing to us. Then we will write that letter to you, and that's considered an informal opinion or an informal analysis of your situation. The opinions that I referenced today, those are formal opinions. Those are issued by the commission body itself. Those take longer to do. Informally, you can get an answer usually, within a week or two, depending on what your time frame is. The official ones of the commission, they meet every 6 to 8 weeks. Their agenda is set 2 weeks prior. That means any work on your request has to be done by that deadline. You have to make it in writing. It has to be on a real situation that you are facing. You can seek it. An attorney that you hire to seek it for you, they can also seek it. But you can't seek an opinion on somebody else's conduct, and they can't seek an opinion on your conduct. You don't have legal standing. But you lay all the facts out in writing. It's not an investigation on our part. We take you at your word. We may have questions. Staff will draft an analysis. The commission will vote. When it goes before the commission, you can speak to them. They may have questions. Once they issue it, you get an official copy, and then it's published on the website. Okay? better to ask before you have a problem than after. We'd rather answer your questions now than investigate you. One final question before we go?
Informal, is that public record?
They are public record, but they are not published. So if you seek a written opinion from us and then you stand up in a meeting or you're sitting in a meeting and you say, I contacted the commission about whether or not I had a voting conflict, and their opinion was no, I did not, so I'm going to be voting on this measure despite John Q. Citizen claiming that you have a conflict, you say that you will be. If that citizen then calls us and says, you know, he said that he talked to the commission or he got an opinion from the commission, we'll search it and say, well, yes, you know, yeah or no. But yes, we did write a letter. Here was the facts. Here's, you know, they can have a copy of that, public record. All right, sorry I ran a little bit long. I do appreciate all of your questions. I'll tell you, county commissioners, they ask the best questions. I have been studying my brains out in the last couple of weeks just because you always have just such a great variety of questions and just so engaged. And I just really want to tell you how much we appreciate your service to the public and your interest in the ethics laws. And I hope that I have some of you sort of in shock. And I hope that some of you are a little freaked out. And I hope that you have more questions now than what you had at the beginning of the session. Then I've done my job, okay? So I wish you luck. I hope I never see you at a commission meeting unless an opinion request. Thank you.